What's going on, everybody? Back again. We're outside, another day, brand new gym, same guy, different shirt. Let's go. First off, I want to start off by saying thank you guys so much for all the love, the comments, the likes, the shares on the first video. I broke down why I hate template sellers. And if you want a recap on the things that I've done along with my team, go check out that first video again. And remember, the more you know about anything, the less fear you're going to have about it. And the CEU was put together with the intent to transform the uninformed consumer into an informed and enforcing one. Like I said on the song Too Easy, there's nothing more dangerous than an informed consumer. Now in the last video, I dropped gems if you happen to be the plaintiff. But what if you're the defendant, right? What if you're the one that got sued by a debt collector? You know, what do you do if that debt collector decides to sue you? Well, let's get into it. And
this is not legal advice.
Yeah, they know that.
This is for educational purposes only.
Of course they're gonna do that.
Do your own due diligence.
I mean, they know better, man. They're gonna check. I'm gonna drop the facts right here for you. But anyway, let's get to it. First and foremost, answer. You have to answer. Even if it's just a general denial, even if you don't understand the cause and the action against you, you just have to answer so you don't get a default. But I know, Jesse, they're using all the statements against me. That's cool. That's why we got Pacific Concrete FCU versus Kauanoe. And I know I'm probably saying that name wrong. Now, a lot of people going around and they're saying that case law, and they're saying that says statements are insufficient to prove a debt. Now, that is true, but why? The why is what's important. And the why in this case is because the statements weren't sworn to. If they're not sworn to, then it's hearsay. And if it's hearsay, it is inadmissible in court. That means that it cannot be used against you. And I know, right? What if they do swear to it? Well, they can only do that if they have first-hand knowledge. And if you don't believe me about them needing first-hand knowledge in order to swear to it, go check out Federal Rule of Evidence 901. Oh, but wait a minute. What if they do all of that? You're telling me that they were there and they witnessed every single purchase that was made on that credit card? They can attest to the fact that you in fact were there using the card to get those goods and that you actually got them on the specific day they said you did? Did they see you? You see, the burden of proof is something that's very important, and it's time for us to start putting it back on them. And what I mean by that is, it's not up to you to prove that it's not. It's up to them to prove that it is. Hey, the more you know, the less you fear. And if you're tired of getting gripped by fear or just facing different roadblocks when it comes to this litigation, man, I want to let you know that we have a huge announcement this Saturday, and it's going to be on Zoom, a completely free Zoom. This Saturday, you can register at themightyceu.com. It's going to be this Saturday, 12 p.m. Pacific Standard Time, 3 p.m. Eastern. You already know it's going to be gem-packed and jam-packed. We got a Q&A going, man. Tap in. It's completely free. Go to themightyceu.com.